Hello, and welcome to Atlantic Debrief, the Atlantic Council's Europe Center's internet show and podcast on the most pressing issues impacting transatlantic relations today. I'm Fran Burwell. I'm a distinguished fellow at the Europe Center, and it's my pleasure to welcome Brando Benifei, member of the European Parliament and co-rapporteur on the EU's Artificial Intelligence Act. Brando, a warm welcome.
Thank you. Thank you very much. I'm very happy to be in this podcast.
On June 14th, the Parliament voted to approve its version of the EU's AI Act, and there will now be several months of negotiations with the Council, representing the member states. We could have final approval of legislation as early as the end of this year or possibly early 2024. The Spanish presidency of the Council has just in the last day or two submitted a paper. That's only 3 days into its term, so I think it's a pretty good indication that the presidency wants to go fast and address this in a very serious way. To unpack the position here of the European Parliament and discuss the significance of the EU's AI Act, I want to jump right in with the first question, which, Brando, is to ask, why an AI Act? What motivated Parliament to address this question? And I want to point out that you've been working on this since long before ChatGPT came into play. So what are your goals in trying to regulate AI?
Well, the idea of an AI Act was discussed already some years ago in the European Union, in the European institutions. In fact, the European Commission that proposed the first draft of this act, on which the Parliament and the Council of the Governments of the European Union has worked on further with their own versions of the text that will now be, they will be now under this negotiation to find a final text that will be approved, hopefully in due time in a few months from now. The Commission, before submitting this proposal, has created a board of experts that worked on the idea of putting into law a risk management framework, risk reduction framework that is at the core of this regulation. And this kind of systems, this kind of agreements also have been already in place for some time, both in public context, in public authorities, in businesses, in agreements inside the industry, to mitigate risks and to have an ethical and responsible approach to AI. The idea of the AI Act is to try to put this into a codification, so to have a classification of AI systems based on different levels of risk, and provide with different rules based on the levels of risks that each use of AI can deliver, so that with these rules we could together mitigate risks for the use of AI and instead multiply the opportunities and the positive outcomes of the intake of AI in our society. So it's the idea of having a human-centered development of AI, based also on some pillars of the European approach when looking at the innovations like this. That is a high degree of protection for citizens, consumers, but also to smaller businesses, to workers, and an attention on data protection. So we can see this influence of these principles behind the idea of an AI Act, which is now something that to some extent is influencing the discourse also outside Europe.
So can you be specific about what exactly the AI Act requires? I mean, I know we don't have a final text, but when you look, for example, I know that in the very highest risk categories, there are a few things that are actually banned. And I know that there's the high risk category is the one that has received the most attention, with people trying to figure out if what they're doing with AI is high risk or not. But if one did deploy a high risk AI, what do you have to do? What does a company have to do?
Yes, if the use case of AI is under the categorization of high risk, which means that it needs to be in one of the areas of potential high risk, and also it needs to pose concretely a significant risk to health, safety, or fundamental rights of an affected user. In this case, the business that wants to, the developer that wants to put into the market their system needs to perform a conformity assessment procedure. So to follow a series of obligations on which we are still negotiating. In fact, it's one of the topic of negotiations with the council are the exact obligations, but broadly speaking, they are regarding data governance, appropriateness of data used for training of the AI, technical requirements of various kinds, human oversight capability on how the AI performs, and other requirements that try to reduce all risks linked to the use of AI. Also, for example, on the side of the discriminations that are unfortunately an easy case for problems caused by an AI that has been trained with data that is not of the highest quality. So we have identified these obligations, and obviously the respect for these procedures will be under the responsibility of the AI board coordination body that we will establish at European level, and also the national supervisory authorities, which will need to have a mix of competences on data protection, on market surveillance, and on competition, which will all need to be taken into account when looking at the respect and the enforcement of this legislation.
Right. So, but a company that's not European, for example, or even a European company, if they want to put AI on the market, would have to demonstrate, for example, that they've trained their AI on a high quality data set or something like that. Is that, or that they have, a user would have recourse to a human being if they feel an AI took a decision against them. Is that basically the idea?
Yes, yeah, and the idea also is that we build a sustainable and balanced chain of responsibility between the provider and the deployer and the final affected user, so that we do the risk mitigation where it's best done, where it's best possible by the various actors involved. And as you said, also, I didn't mention that, but you said it, we also identified unbearable risks. So areas where the use case is too risky and we just don't want that to happen. So we ban it. That's the real-time biometric identification in public spaces. That's predictive policing. That's emotional recognition in workplaces and in schools, and some other areas where we think that there is not enough benefit confronted with the risks that are put in place, and so we don't want that to be possible in Europe.
So you're now starting, we've had a couple of the first trialogue negotiations. And what do you see? I mean, you mentioned we don't have a final text yet. There are differences between the Council and the Parliament, and certainly differences from the Commission's initial draft. What do you see as the key issues that will dominate these negotiations? And are you expecting them to move forward rather quickly, or is this going to be a tough slog?
It's not easy to foresee now, because it depends also on how the council will engage with the parliament. We are open to find compromises on many topics, but we also will have to defend a general approach from the European Parliament that is very careful and attentive on respect of human rights and on data protection. So we will need to find agreement, knowing that there are some more problematic issues, like the bans, where we see differences with the governments, especially on those that deal with security areas. And the generative AI, where the European Parliament has proposed clear rules about watermarking of AI-produced material, copyright protection, and fighting illegal content, and also identifying the deep fakes. So we have given some clear obligations on generative AI side, which are new. The governments didn't really confront with that, and we will have to discuss about that more.
Well, if I recall correctly, the council developed its position maybe just before ChatGPT was released, and but Parliament was still talking about its position, if I recall. It was before your final votes. How did the introduction of ChatGPT change, if at all, what you were doing in the way you were looking at AI?
Yeah, it changed the discussion, because although some of the political groups in the parliament and some of the governments also, they were eager to include general purpose AI, generative AI, large language models in the scope of the regulation. In fact, there was not a majority to work in this direction before the explosion of generative AI, also at the consumer level. We have seen a change. We have seen a change in the mood, in the discourse, and now there is no big deal, no big contraposition on the need to find a sensible regulation for generative AI and general purpose AI in general, which is a bit elusive in front of this regulation that is much use cases based. So I think it's one of the points where the discussions with the council will be more important, and there is more on which there is more expectation and public attention.
So can you tell me how, in developing the legislation or Parliament's position on it, how you engaged with particularly business stakeholders? I mean, was that something that you have conversations with major companies and others? And one of the things I want to ask you about is many of the companies that are engaged in this space, not all, but many are American. And there's often a charge that EU regulation stifles innovation in Europe among European companies. How do you react to that, given AI, given the AI Act? Will it stifle innovation? How do you feel about that? And how did your business interlocutors, what was important to them?
I have to say that I don't really understand how this regulation could stifle innovation for the European companies, because this is not applicable only to European companies. It will be applied to all companies that develop AI systems that will be presented to the European internal market. So it could be criticized, obviously, but it's not affecting only European companies. In my view, the difficulties, the delays and the lagging behind of Europe on this topic compared to US to some extent, but also to China, um, it's linked with other factors. That is because, in fact, we don't have the legislation now in place and we are lagging behind anyway. Why? Because the European Union is divided. The US and China are united. They do common investments. They have a financial sector with also the venture capital that is of a higher development, and they have the work of the academia, strictly linked with the research at the highest levels, computational capacity, investments that are happening with both the private and public level. So I think the European Union should regain the lost track on these aspects that are very political in terms of the unity of the European political institutions towards the development of AI, more than an issue strictly related to regulation, which obviously needs to be fit for the competition, for supporting innovative business ideas. And in fact, we are working on sandboxes that are there to help new businesses, new startups to develop and to overcome the competitive gap with the bigger players. But I have to say that it's been very important, and it will be still very important for all next phases to discuss with business stakeholders, because they know how the whole system functions, how this ecosystem is organized. And so we did and we will continue talking with businesses from all sides of this debate. So the ones that develop AI, the bigger ones and the smaller ones, and also those business that use the AI, buying it from others, and they need to know what's their position in this context.
So, if the AI Act is passed at the end of this year, my understanding is that when it is passed, it will still take 2 years to come into effect. But AI is developing rapidly. What do you see as the steps? I know there are some proposals for guidelines, etc. What do you see as an interim step that would be effective?
Yes, it's correct. First of all, we will need to check and see what will be the final agreement on the entry into force timing, because it might be also reduced a bit, maybe on some aspects of the regulation. But yes, on paper for now, it would be 2 years, so beginning of 2026. But we will see what will be the final agreement. Also, as you also mentioned, there is a debate and there is a work ongoing about voluntary compliance and code of conduct on AI. There is a pressure in two different directions. The so-called AI Pact from the European Commission that will support and push the businesses and public authorities to apply the AI Act rules before their formal entry into force, to adapt gradually to it. And this is especially promoted by Commissioner Breton. Then we have another initiative, the AI Code of Conduct, that is led by Commissioner Vestager, which is more linked with the idea of a global agreement, at least at G7 level, on the code of conduct for generative AI. So to have a minimum set of rules regarding the generative AI, which are of particular attention now also for their potential for impacting democratic processes, the misinformation risks, and also for their consumer impact, because they are now used very freely and easily by hundreds of millions of people already.
So, you know that in the United States, we are just coming, this is our final question, but let me ask you, in the United States, we are coming to a discussion about AI in the wake of ChatGPT's release. And there's been some movement on the Hill. Senator Schumer has established a new committee. Based on your experience, I mean, you've been doing this for quite a while during this parliament. If I recall correctly, you had a special committee, or the parliament had a special committee. What would you advise U.S. lawmakers in terms of their approach to AI and how to make themselves a good legislator on such a difficult and technical topic?
I think whatever will be the decisions in terms of taking the steps like the EU to have a hard legislation or to take other ways, it will be very important, as it was very important for us, to have a space for discussion and exchange with experts, academia, stakeholders of all kinds working on AI, like we did with the special committee. The special committee in the European Parliament was a non-legislative committee. It didn't work on the legislation. The legislation came after. But this 1 year work of committee on AI, the name of the committee was Artificial Intelligence in the Digital Age, was crucial to learn the state of the art of the discussion outside the legislative chambers of the AI, looking also at existing voluntary frameworks, existing rules that were non-legislative, non-binding rules, but already applied in the business sector, in the public authorities area, and so to learn what was the self-regulation already happening. And understanding all the angles of view on the AI and its putting it under a certain degree of governance and regulation. So it was an important work that I think would be important also on the side of on the other side of the Atlantic, if this committee will be used to get an in-depth knowledge that I think is partially lacking. I know it is lacking in the legislators here, but also with my discussions with some congressmen and women that in the US that are more expert on this topic. They also realize that there are too many politicians that don't really understand what's happening with AI, and we need to build more understanding so that we can also build together solutions. This is what we have been doing, and this also as an impact at the global level. We need to work for a global discourse, and we hope we can do some Brussels effect, as you know we call it, to push the debate in the direction that we like. The idea that we can deliver an AI that is compatible and not damaging for our democratic values. This is something we are very much caring about.
Brando Benifei, thank you very much for joining us here today on Atlantic Debrief and to discuss this very important topic. We'll be watching as the trialogues progress, and I'm sure that we will revisit this topic before the end of the year when we have a better feeling for the exact final form of the legislation. Thanks again, Brando Benifei.
Thank you. Thank you. Bye-bye.